My name is Stephen Kazan. I'm a trial lawyer in Oakland, California, and I want to talk to you today about the sources of the law under which our civil justice system operates. Our society today functions largely based on oil and electricity, on power, with machinery. Back in biblical times, of course, they didn't have all of these devices, and instead their equivalent of the tractor, the locomotive, the truck was oxen. Oxen were big, they were powerful, they were strong, they were able to do a lot of work and accomplish a great deal for the people, and as a result they were very, very important. This is an illustration of a team of oxen plowing in ancient times. This is an image from an Egyptian tomb. Here's another image from a mosaic floor in that era, and here's another Egyptian wall fresco. So oxen were very important. Obviously they were very big. You can see they had big horns. They were potentially dangerous. And the Bible talks about the law relating to oxen. What's of relevance to us today is this provision in Exodus 21, verse 29. If an ox was known to gore people in its past, and warning of this was given to the owner of the ox, and he hasn't kept it confined, locked up within a fence, in his house, in his corral, and the ox gets out and kills a man or a woman, the ox shall be stoned by way of punishment to the ox, and the owner shall be put to death. Very much like the Code of Hammurabi and the builder who builds a house that collapses and kills somebody, the builder gets put to death. But here the Bible changes the law. The law in the region has now evolved over the past 800 or 1,000 years, because the very next provision in Exodus, if there be laid on him, the owner, a ransom, then he shall give for the redemption of his life whatsoever is laid upon him. What this means is, if it is determined that there is a price, an amount of compensation for the damage done, the owner of the ox has to pay that compensation instead of having himself put to death. This essentially takes the law of an eye for an eye and turns it into a rule of compensatory damages. It's the value of an eye for an eye. It's the value of a tooth for a tooth. And this is a major change in the law, a major change in the way society is organized. And what this means, of course, is that you have to have somebody who determines what this ransom, what the damages are. This is not criminal law. This is a civil justice system that has nothing to do with the state or the government. If somebody gets killed, their family is entitled to compensation from the person who is responsible. And note, I didn't say the person who is at fault, because there doesn't have to be negligence here. Do we have rules that are exactly like the Bible for animals that can be dangerous? Well, yes, we do. In California, there are specific rules for the strict liability for injury caused by domestic animals that have dangerous propensities. The law says that people who own, keep, or control animals with unusually dangerous natures can be held responsible for the harm that their animals cause, no matter how carefully they guard or restrain their animals. If you have a pet lion and he gets out, it's on you. It doesn't matter how it happened. If the plaintiff, the injured person, can show that the owner knew or should have known that the animal had this tendency, he's responsible. So it's not actual knowledge, it's should have known. This is a basic rule of civil liability. Our modern civil justice law, our tort law, in fact has its foundation in the Bible and reflects some evolution of belief, some increase of knowledge, maybe some increased sophistication. But when anybody tells you that there's something wrong with our civil justice system, I think it's reasonable to say, hey, you know, It's just from the Bible. It's the way civilization has been in the Western world for 3,000 years. There's nothing wrong with it. People ought to be held responsible for what they do and pay for the damage they cause. Thank you.